And let's begin. Good morning to all on Saturday, November 19th, 2022. I'm Greg Nicolaysen in Los Angeles, thanking everybody for taking time out of a busy Saturday to join us for another White Collar Roundtable webinar. Today we address a critical subject for all white collar practitioners: criminal enforcement priorities and practices under the Biden administration, specifically as to corporate crime. Early on, the administration quickly pledged to increase corporate criminal enforcement after a decades-long decline. In October of 2021, Deputy Attorney General Lisa Monaco issued a memo announcing that DOJ is convening a corporate crime advisory group. The first sentence of that memo reads, "Fighting corporate crime is a top priority in the Department of Justice." And as recently as September of 2022, Deputy AG Monaco issued a memo entitled "Further Revisions in Corporate Criminal Enforcement Policies," which issued directives to DOJ as a direct follow-up to that advisory group. But where has all of this policy writing brought us now that we are approaching the 2-year point in Biden's term? That will be a central focus in today's program. And to guide us through all of this, I am deeply honored to have two leading white-collar practitioners with us, both from the firm Womble, Bond, Dickinson. I'm going to be introducing them to you at this time. First, Michael Clark from the Houston office. Mike needs absolutely no introduction to most, if not all, of the attendees of today's program. Since his tenure as an assistant U.S. attorney in the Southern District of Texas, where he was chief of the criminal division, Mike has served as lead counsel in over 100 jury trials and has handled dozens of appeals. As senior counsel presently with Womble, Bond, Dickinson's Houston office, Mike's wide range of litigation matters has included defending healthcare professionals and providers, as well as other white-collar matters ranging from environmental to tax, fraud, and money laundering, to name just a few. Mike's many accomplishments has included serving as editor of the 2022 edition of the treatise Corporate Criminal Liability, published by Thomson Reuters, which I highly recommend. Mike is also the founder and chair of the White Collar Law Group on LinkedIn, which has 15,000 members. And our second panelist today, and very appreciative of his time, Luke Cass. Luke is a partner at Womble, Bond, Dickinson's Washington, D.C. office and a member of the firm's White Collar Defense, Investigations, and Regulatory Enforcement Practice Group. Luke's practice focuses primarily on the defense of white-collar crime matters, as well as internal investigations and compliance. Just a quick history on Luke's background. Luke has served as a federal prosecutor with DOJ for over a decade. First, as an AUSA in the Financial Fraud and Corruption section of the U.S. Attorney's Office in San Juan, Puerto Rico, where his prosecutions included financial fraud and public corruption. Later, as a senior trial attorney with the Public Integrity section of the Criminal Division at DOJ, which investigates and prosecutes some of the most sensitive and contentious public corruption cases handled by the department, including matters involving elected and appointed officials. Luke's many credentials include serving for the past 5 years as an adjunct professor at the Georgetown Law School, where he teaches a course on white-collar crime and securities fraud. My heartfelt thanks to both of you for being here today, and certainly my welcome. So let's begin. Mike, I am going to go ahead now and post on the screen the outstanding PowerPoint presentation that both of you have prepared, and I'm going to hand you the WebEx ball, which makes you the chief moderator of the program. I'll go ahead now and turn the floor over to you and Luke with my heartfelt thanks.
We're really pleased to be invited, Greg, to talk about this topic, and appreciate everybody who's tuning in to participate. It's a interesting presentation, at least I think it should be, getting kind of a historical perspective of where we've been and where we may be going. We're looking at some signposts along the way, but I know this is a topic of great interest, and we have now Luke and I were chatting. We now have a special prosecutor appointed for potential president or past president. So things are getting very, very interesting. That's really not a corporate criminal enforcement priority, but it is a DOJ emphasis right now, and so it's worth mentioning that in a footnote. So what Luke and I are going to do is we're going to try to be a little bit interactive, going back and forth in talking about these issues. That way, you don't get a monotone from us. But Luke is going to begin by talking about the principles of federal prosecution of business organizations. Then I'm going to move into talking about the evolution of the DOJ policies. Luke will talk about corporate charging factors. I'm going to talk about the reemergence of priorities on corporate monitors. We're going to move to talking about some shifts in direction with the Lisa Monaco enforcement policies and takeaways. And then I'll talk about the evolving issues and DOJ compliance program guidance. Luke will talk about voluntary self-disclosure versus cooperation. I'll talk about corporate resolutions and what goes into that. And then Luke will pick up with amplifying that, and we'll have a little bit of banter back and forth. The last slide we're going to talk really about is RICO issues, and then we will talk about the outcomes. So that's kind of a coming attraction for the next hour or so, and we really appreciate again the opportunity to kind of weigh in. And obviously we're interested in other people's thoughts, and we don't want to basically be saying that we know it all, but we think we have some good perspectives, and we hope to share them with you. So I'm going to try, Greg, to advance the slide, and let me see if I can do that. I am having a little bit of difficulty for some reason. Let me try that.
No, it's quite all right. The carrot over on the right, you see there's like a little triangle to the left and to the right of that 0-1. So I'll take the ball from you for just a moment.
Yeah,
Mike.
I'm sorry. I'm just trying to find it.
Hit that little carrot there. And it
Yeah, I just found it.
Okay, real good.
I'm there, so I apologize. We've basically just laid out what I just showed you on the slide too. So now we're going to move to the principles of federal prosecution of business organizations. And Luke, you can take that one if you don't mind.
Of course, Michael, and thank you, Greg, for that very kind introduction, and for everyone tuning in. So let's start with talking about the principles of federal prosecution of business organizations. These are about 23 years old now. They debuted in June of 1999 when Mr. Holder was the then Deputy Attorney General. And these were the governing dynamics, or the standards of different factors that you should consider as a federal prosecutor in making charging decisions against corporations. Focus on individual wrongdoing from the beginning of any investigation. You'll see the Justice Manual citation of where that is in greater depth. That you should not treat a corporation more leniently or harshly because of their artificial nature, and that prosecution of a corporation is not a substitute for individual culpability. And of course, the consideration of any prior criminal, civil, or regulatory conduct. When this first came out in '99, as I mentioned, the Holder memo, which debuted these policies, stated that whether the corporation waived the attorney-client privilege or advanced legal fees to culpable employees should be considered when evaluating a corporation's cooperation. The result, as you might imagine from that, was a lot of folks just waived privilege and wanted to obtain leniency from DOJ. And this has evolved through the different administrations and has been interpreted largely based on a reflection of what's been going on in the enforcement world. For example, you fast forward a little bit to 2003, when the Deputy Attorney General was Larry Thompson. Remember, at this time, you had Enron, you had WorldCom going on. He continued to indicate to federal prosecutors that they should consider the waiver of a privilege and encourage them to scrutinize, quote, the authenticity of a corporation's cooperation, including whether they impeded the investigation. Move forward a little bit more after that into 2006. There was some bad case law that came down as a result of that push for privilege waivers when you're cooperating. And in 2006, Deputy Attorney General's Paul McNulty, he forbid prosecutors from seeking information based on the attorney-client privilege without first establishing a legitimate need for the information. And then in 2008, when Mark Phillip was the Deputy Attorney General, he completely removed that consideration of the waiver and even the payment of employees' legal fees as factors in corporate charging decisions. And that last one, the payment of legal fees, you'll see when Michael talks about it, will be an important aspect in the Monaco memo changes.
So kind of setting the stage on what had happened in the KPMG case, the district court went with the defense that we're saying essentially that the Sixth Amendment right to counsel were being interfered with and violating due process, because when you are told that a company can't fully cooperate if they continue to advance attorney's fees under an indemnification agreement, the DOJ has really no business going that far. It's really a matter of state law and respect for the dual sovereignty issues, and you intertwine that with the idea that how can you really require in a proceeding that a company that is contractually obligated to advance fees not do it, or they'll be seen as not properly cooperating. And of course, then it got drilled down into, well, are the advancement provisions under Delaware law, are they mandatory? Are they discretionary? And I think that was the right result, quite frankly, that, you have a coercive enough environment without DOJ telling companies, not only do you have to turn over and waive privileges to fully cooperate, but now we want to know who you're paying, and if you're paying for the attorney's fees of individuals we don't like, stop it. So it was repugnant, and because of that, the Thompson memo was basically it went too far. So let me move to the next slide. We have the Yates memo, the Rod Rosenstein changes, and the Monaco memo. Again, it's an evolving continuum here that we're really talking about. What were the priorities? Well, when Sally Yates issued the Yates memo, it was basically kind of revisiting the whole idea of what type of individual accountability is necessary for corporate wrongdoing. There had been a lot of backlash following the Great Recession of the 2000s, and what we saw, as you recall, during that period of time is that a lot of the big Wall Street banks were happy to come in, and I wouldn't say happy, they went in and negotiated non-prosecution agreements or things of that nature in the main and paid off a lot of money. But very few potentially responsible individuals were criminally prosecuted, and that created some questionability in the press and as to the department about, why do you have to do this? Why can't you go after the individuals who arguably were doing things or asleep at the helm? Kind of digress for a second. I watched with some trepidation what was going on, because I cut my teeth as an assistant U.S. attorney in the Southern District of Texas when we had the bank fraud crisis in the late 80s and early 90s, where every bank had failed in Texas, it seems like, except maybe one or two, and didn't fail just once. Some of them failed 2 or 3 times. But with that in mind, I was over the financial fraud division. At that point in time, we learned how to investigate and prosecute banks, and we did so successfully. I think the difference, though, in that time was that the money was out the door generally. Banks didn't have the money, to pay DOJ at that time. A lot of the banks were basically dead entities. So then, you looked at, well, where should the responsibility lie? And there were a lot of individuals. But out of the Great Recession, there were a couple prosecutions and they did not work. And the argument was, well, these are incredibly complicated cases. And, at this point in time, getting in and making the company own up to what it did and implementing changes that would be useful is what we need to do. I think we can move, kind of past the Rod Rosenstein changes during the Trump administration. There was a little bit of retrenchment on the idea of individual accountability. It seemed like it was still there in word, but not nearly as much a focus on individual accountability. And so, some of the complaints about what happened during the fallout from the Great Recession and the major banks kind of continued under the Trump administration. And so when Monaco came in as the DAG, the focus has now shifted back to the whole idea of individual accountability is important. Just because a company is willing to take a plea if need be, doesn't mean that the individuals who may be responsible shouldn't be investigated and or prosecuted if that is essential to securing justice. So that's really the focus, and it's kind of a revisiting of where we have been. Now, it remains to be seen how that will play out. There are some permutations in the Monaco memo that we'll be talking about with the DOJ. And for example, the idea that corporate monitors now need to be thought of more often than before are important. And kind of going back in time, corporate monitorship was under attack because of the way that the corporate monitors are being selected. The argument was it was kind of a good old boy network that was being used and it should be more transparent and open. And, frankly, if you have a compliance monitor, it's a whole lot more cost, and is it really necessary? Obviously, if I'm representing an entity and there's a criminal investigation, one of the first things I'm going to be trying to do is to assess whether or not their corporate compliance program needs to be tweaked, and changes need to be made organically, because that at some point in time that will be an issue. A corporate integrity agreement in the worst scenario is going to be basically what I would refer to as a compliance plan on steroids with added costs. And then if you have to have a corporate monitor measuring and reporting back to DOJ about is the company meeting its metrics, it's kind of a nightmare scenario, because the company can't really operate free from oversight by government monitors. And, for the period of time that they're under that, the government is really working to change their corporate culture. And at what point, realistically, does the government need to be that involved in corporate affairs? As you talk about, why do corporations want to raise capital and spend capital? The government being involved does tend to stifle innovation. The question is one of excesses. So let me move to the next slide.
Michael, one thing to add on the Rosenstein memo, one good aspect of it, I think, at least in practice, was it restored some common sense discretion to the line prosecutors, where it still focused on individuals, as you said, but it wasn't an all or nothing approach. So if you meaningfully assisted, you would get some credit, as opposed to no credit at all if you didn't do X, Y, or Z. So I thought that was an important and valuable aspect of the Rosenstein guidance for practitioners.
And that's a good point. And one of the things we haven't really talked about in the evolution of corporate cooperation and privilege waiver as kind of a refinement to the Thompson approach. The government realized, the DOJ realized, that they really have little to no business in asking for the waiver of work product as it relates to the most protected type of work product. So now what you see is they're only saying if you're going to waive, we would like to get fact work product, documents and whatnot, but not the mental impressions or what is called core work product, because that is the most protected. And, you know, if that has to be waived as a default, it's probably going too far, because again, it tends to impinge on the sanctity of the attorney-client relationship.
Yeah, that's become trickier, hasn't it, Michael? There's a couple cases out there now, district court level. One that just comes to mind out of the Southern District of Florida called SEC versus Herrera, where the judge found that if you identify the person that you interviewed, that waives work product, which kind of puts you in a bind a little bit when you're trying to get cooperation credit and you can't disclose who has this particular information to the government for fear of waiving it.
It gets very granular when you start talking about the whole idea of selective waiver. The Eighth Circuit is really the only one that has recognized the idea, and that's Diversified versus Meredith. But, you know, the government will give you a agreement that, you know, that essentially that you haven't waived privilege, but it's probably worthless. And, you know, there's other situations that come about when you're not dealing directly with the government, but when you're dealing with auditors, for example. After the fallout of Sarbanes-Oxley and Dodd-Frank, the reform measures, auditors are basically independent at this point, and they're watchdogs. And so the idea of saying that, you know, when an auditor asks for things and you turn it over, can you say that they are aligned? Is there a common interest? I think it's arguable at best and dangerous. And so typically when I'm involved in representing an entity and the auditor is pushing, I try to interface with the auditor and get a dialogue going, basically trying to figure out what do they really need and are there alternatives to actually disclosing what otherwise might be privileged. And I've had success doing that. So there's a myriad of different considerations that come into play. We haven't really broached the topic of parallel proceedings, but these issues come up commonly when you have a DOJ investigation, because you're also going to have, if it's a company, you're going to have the worry about lawsuits being filed against the board of directors for not fulfilling their Caremark responsibilities, and it gets very nuanced. And so, of course, the company doesn't want to admit to any wrongdoing, because that would then potentially be collateral estoppel in any private suit. So it's kind of dangerous in that regard. And when you have, as Luke mentioned, when you have these my way or the highway type of edicts, you know, it's a little bit hard to navigate through that successfully. And sometimes you have to have a candid conversation with a company. Look, you know, avoiding criminal liability is probably the most important thing here. You know, as far as being sued, class actions and securities type cases, things of that nature, you know, it's getting to be more dangerous. And, you know, with the new SEC focus saying that there has to be more admission of wrongdoing, these are all becoming more difficult issues to navigate through. So let's talk about the corporate charging factors, Luke. I think this is going to be you taking the lead on this, if you don't mind.
Yeah, and just to follow up on what you said, I was having a conversation recently with someone from DOJ, because the rhetoric is so hot on some of this stuff, Michael. And I was saying, you know, you don't want to signal that the cooperation process is as arduous as litigating the issues, because then it disincentivizes folks coming forward, you know, on a lot of these things. So, but it's evolving. Let's see. But corporate charging factors, to charge or not to charge, these are the specific factors that the department will take into account: the nature and seriousness of the offense, the pervasiveness of wrongdoing within a corporation, if it has a culture of corruption or non-compliance, history of similar conduct. And this was an aspect that Deputy Attorney General Monaco elaborated on in making her announcements that the scope of that has been enlarged. So now the department is considering the full criminal, civil, regulatory record of any company when reaching an appropriate resolution. Obviously, if they're dated, they're not going to be accorded great weight. I think criminal resolutions that occurred more than 10 years before the conduct and civil or regulatory before 5 years will have less weight. It's sort of discretionary at that point. Willingness to cooperate, we'll talk about that more in depth. And the compliance program at the time of the offense, there's been a great amount of emphasis placed on this factor in particular. And the new chief of the fraud section is actually a former compliance expert from HP, and they brought in other folks on that as well. The timely and voluntary disclosure of wrongdoing, there's an immediacy to bringing that information forward if you want to get full credit. They've made that abundantly clear. And then, of course, remedial actions and collateral consequences, which Michael mentioned, and remedies, and whether the individual prosecutions are adequate, or you have to go further and charge the company. But these all depend on the facts and circumstances of a particular case, as well as the actual entity and its history. But these are the general guidelines and factors.
So when you get into one of these representations, I had one a couple of years ago that comes to mind where there was a call saying, "We've gotten your name. It's a lab. There's a search warrant executed at our facility. We don't know what it's about." It's kind of a step-by-step process. You have a discussion with the client about, well, here's the issues on the table right now. The first thing to do is, once I get retained, is to reach out to the DOJ fraud task force lawyer, find out, what they need, because oftentimes when you have a search warrant, there's also going to be a grand jury subpoena issued to seek the same records that they have looked for. And so you start getting into a discussion about a rolling production. What do you really need right now? What can you tell me about the direction of the investigation? There's always a willingness to cooperate. So it's kind of an interesting dialogue. And before we started our presentation, I was visiting, and Luke and I were visiting with Greg about how the culture seems to be changing within the Department of Justice in the last decade or two about the openness or the lack of openness. And that's disturbing, because when you're in a full cooperation mode and you're saying to them, DOJ lawyers, look, we don't want to step on your investigation, but you can imagine in light of this, we have to do a kind of what I call a reactive internal investigation to figure out what happened and why. It's important to have a dialogue. So if there are individuals that you don't want us to be contacting or doing anything, we'll try to coordinate with you, but we got to do our job. And if you think that there are remedial actions that need to be taken, let us know. Those are the types of things that you have a discussion with, and it's not easy to have a meaningful discussion if the government's position is it's too early to talk to you, but we want this stuff yesterday. And I seem to be encountering that, and not going into great war stories, but when you're basically making presentations blindly to the government to try to get them to talk to you, to show that you're cooperating and that you're trying to help them, and there's no reciprocity, it's just a difficult scenario that we deal with. And
there could be a middle ground, right, too, Michael, where I know they want to protect their investigation. No one wants to compromise the investigation, but there has to be some feedback as you're giving information to see how it's landing in the process, right? It's very difficult, I agree, when it's just radio silence on the other end.
Yeah, and in my particular matter that comes to my mind, we had outside counsel advising on compliance and other issues. It was a very arcane issue, and floated the trial balloon of perhaps having outside counsel walk you through what they did and why. was too early to talk about that, is what I heard back. And you know, it kind of changes perspective. When I was a federal prosecutor, if defense counsel wanted to share with me things that otherwise might be important to my charging decision early on, I was all ears. Yeah, come on in, let's talk. I appreciate it. You know, let's hear what you have to say. So I don't really understand this evolving mindset in all candor. I think it's a mistake, and I don't know if it's something that others are experiencing or not, but maybe it's just a generational thing. But certainly it's a different perspective of how to go about doing business, and it certainly doesn't seem to me to be a very efficient way of getting to the end result that needs to be obtained.
Right.
So these are always tough issues, and you know, as you look at it, what's not up on the slide, one of the first things you look at is what kind of insurance is available. Is there D&O? Is there E&O? And things of that nature. And sometimes it gets kind of granular. The insurance company may say, well, there really hasn't been a claim yet, so we're not really going to advance fees until we know that the DOJ is actually doing something. And then, you know, if you have to go to the DOJ and say, are you going to do something? That's counterintuitive. So, you know, again, you have to kind of, sometimes you have to have these nuanced discussions, I guess is the best way to put it. Corporate monitor policies, we do have the Monford memo available up here. This was Craig Monford, who is the acting deputy AG, and a formalized policy was issued in March of 2008 about deferred prosecution agreements, non-prosecution agreements with companies, and the selection and use of monitors. And it went through, you know, things to take a look at about whether or not a DPA or a non-prosecution agreement would necessarily require having to bring in a corporate monitor. And the whole idea there was, you know, there are attendant costs that need to be considered, and it shouldn't necessarily be the default rule. Under the Monford memo, monitors only should have been used when appropriate after you analyze the potential benefits to the corporation, i.e. changing the corporate culture in a meaningful way, against the cost involved of the monitor with the operations. And I kind of alluded to this in the introduction comments that I made. These are oftentimes going to be things that will prevent a company from undergoing and taking risk, and that stifles innovation and competitiveness. You have to balance that against, you know, at what point is the competitiveness improper? But when the government is essentially running a business, which effectively is what the problem is with corporate monitorship, it has a long-lasting impact on the company. Now, the government wants to change the corporate culture to be more law-abiding and compliant, but there's a balancing here. So in 2018, Ben Minkowski's memo was issued that said that you look at the potential benefits, consider whether the misconduct involved manipulating corporate books and records. You look at whether the conduct was pervasive. These are words we're hearing as themes over and over and over again. Did it make significant investments and improvements to its compliance program? Were those improvements tested to demonstrate that they worked? And so monitors should only be imposed when there's a demonstrated need relative to the cost and burdens. You know, one of the problems, and we're going to kind of get into this later, with the whole idea of, was a corporate compliance program effective? It's what I call the hindsight bias problem. If I'm talking to an AUSA and the company is under criminal investigation, and I'm dealing with an AUSA that is not experienced in compliance matters, it's hard necessarily to say this was an effective compliance program because their answer is going to be, well, how the hell is it compliant when, we're looking at them for potentially having committed a crime?
Right.
And that's the issue on the table. So there's now a standing committee on the selection of monitors, and you have to have nominations of monitor candidates because there were criticisms about this being a good old boy network with plum jobs. There's internal reviews. There's reviews at a higher level by the AAG and approval by the OADAG. Now we shift into the Monaco memo. Every component involved in corporate criminal resolutions that does not currently have a public monitor selection process must adopt an already existing DOJ process or develop and publish its own selection before the end of 2022. But the emphasis, as we've alluded to, has been to go back into the idea that corporate monitorships are a good thing, and particularly so if we're dealing with a company that's a recidivist, or the conduct involved high-ranking officials and was pervasive. So that's kind of where we are right now. And the shift, I think, is basically the government emphasis being that we need to change your culture, and we don't have the time and manpower to continue to investigate you. So at least for a finite period of time, we're going to make you toe the line. We're going to have independent eyes looking at it carefully. And then the problem is going to be that nowadays you've got to have people certifying to the compliance measures being adequate. How would you like to be the individual called upon to certify to that under penalties of perjury with a company that has now entered into a non-prosecution or deferred prosecution agreement? I would certainly want to look very, very carefully at that issue and test it as hard as I could. And it may not be something that would be easy to do. You got to go back into your idea of the Caremark responsibilities. It's kind of grading on, were your actions at that time appropriate, and hindsight bias is going to be an issue there. But the idea that you'd be prosecuted for certifying that this was an effective compliance program, that's pretty dangerous stuff in my eyes. Luke, I don't know if we're back to you, but we can talk about Monaco corporate enforcement if you don't mind.
Sure. Yeah, these are the highlights of the Monaco memo, to actively review the programs to ensure they adequately monitor. The review, as we said earlier, of the entire criminal, civil, and regulatory record, not just a sliver. And just look at that quote at the bottom. Some have questioned whether pretrial diversion is appropriate for any company who has benefited previously from such an arrangement. So if you have a history of a DPA or an NPA, deferred prosecution agreement, or a non-prosecution agreement, and you're back before the department, probably pretty unlikely that you're going to get that type of deal again, based on the guidance. And this is consistent from the Holder memo to Yates, even to Deputy Attorney General Rosenstein's remarks that there is a need to identify all individuals involved in the misconduct, not just those substantially involved, if you want to get credit. And there's no default presumption against monitors. It's a case-by-case determination. And I think that is a great part of the Monaco memo is to have more sunlight on the process of how they are appointed. That's always been something, as Michael said, that was just shrouded in mystery. No one really knew how they were selected. But I think that's a very important point, change that's come into view. With respect to the compliance, we had said earlier in some of our discussions, I think it was Michael, Greg, and I, compliance is now in-house at DOJ. And what we meant by that is the head of the fraud section is a former chief compliance executive. There is a corporate enforcement compliance and policy unit, CECP, now at the fraud section to ensure that there's in-house expertise in compliance, in monitorships, and corporate enforcement matters. And they also hired a specific data analytics expert in that particular unit. He used to be at InBev. He was a former global compliance chief So they have a team of multiple attorneys with experience, significant compliance experience, that will probably work in tandem with the corporate crime advisory group to the Deputy Attorney General. And these are obviously the takeaways. And there's been several monitors that have been appointed in various cases: Balfour Beatty, NatWest, Stericycle, but in Lafarge, which was a French cement company paying bribes to do business with restricted ISIS network folks, did not have a monitor in that particular case. But even in those plea agreements, if you could take a look at them, and you'll have a copy of these slides, there's a hyperlink to the actual agreements. It's negotiated. I think Balfour Beatty, they didn't get a selection. NatWest could put forth 3 or 4 monitor candidates and pick from that. So it's always subject to negotiation, or at least it appears that it is.
One of the things that I recommend to clients early on in a corporate investigation, be it a False Claims Act matter or potentially a criminal case, we need to take a hard look at and compare your compliance program to some of these corporate monitor agreements and civil integrity agreements to see what the government could do or would do. And, if there are refinements we can make now, let's make them as part of our remediation, as opposed to having to wait and then the government comes in and says that this is wholly inadequate. So, that's, again, it's part of the whole process when you get involved in one of these cases, is that you're going to be doing a bit of an internal investigation reactively to try to figure out what happened and what needs to be done proactively. The idea being that if I could avoid the company having to take a criminal information or a criminal indictment, that's really the ultimate goal. Oftentimes you can maybe even convince the government not to prosecute and not to put them under a DPA or an NPA or something of that nature. But as you kind of look at it, if there was a search warrant, we know that means that a federal agent has gone in front of a magistrate judge and sworn that there's probable cause that a crime was committed, and that you're going to find the evidence substantiating that at the location. So it's not like you're going in with an even slate. It's already kind of stacked against you. And so you have to be kind of realistic about expectations. And going back to this whole idea that the emphasis now is looking at holistically the history of the company, how pervasive the wrongdoing is, that's the first thing that you need to be asking yourself. Was there a NPA in place? Was there a deferred prosecution in place? God forbid, are you under a corporate monitorship while this happens? Are you under a CIA when this happens? Because that certainly raises the risk and profile quite dramatically if that's the case. Recidivism is a bad thing, but so many of these companies have now been prosecuted. Large multinational, well thought of companies. It seems like if you look at most of the major players in the United States, they've all had investigations. It's kind of the cost of doing business. And there's a good resource that's available publicly. I think it's UVA that has it, that you can go and look at all the companies that have been subject to NPAs and DPAs and look at some of the documents there. It's a wonderful resource. The whole idea, however, is with the Monaco memo, the takeaways, a lot more emphasis is going to be using data analytics, as Luke has said, to try to figure out what's happened and why. And I just did a panel the other day with one of the high-ranking DOJ officials about the continued efforts of the opioid crisis investigations. And, she talked about just how much data analytics is becoming more and more important to what DOJ is doing and how they're targeting.
And Michael, two other things on these takeaways. On the history of misconduct, it's my it's my hope that these are not rigidly applied and that there's some common sense. For example, in some occasions there's misconduct that's occurred, but it was 2 or 3 owners ago, and it's not the same company anymore. So whether you should penalize them for making improvements and taking a lot of measures to improve is something that I think we'll have to see depending on certain facts. And for the increased role of compliance officers, Michael touched on this a little bit, but they want to implement a compliance officer certification, and the idea is to empower them to create and maintain the programs. But it requires, as Michael said, a certification by the chief executive officer and the chief compliance officer for all criminal division corporate resolutions. That includes guilty pleas, deferred prosecution agreements, and non-prosecution agreements. That certifies that the company's program is reasonably designed, that it's implemented to detect and prevent violations, and that it's effective. And we'll talk about what effective means. But that's a new additional tool that is new. And we'll see how that the reactions to that. Yeah.
And it's very problematic, as Luke is mentioning, because if I'm in a large company with lots of subsidiaries, and particularly if the subsidiaries in foreign countries where there's a history of bribery and corruption, I'm going to be very concerned about, making that certification under penalty of perjury, and I'm going to have to, ask people to be very, very specific to me about what's going on and paper it up, so that if I get a hard look, I can show I did everything reasonable in the circumstances. But this seems to be the trend line where we're going. And going back to Sarbanes-Oxley and Dodd-Frank, more and more people are being called upon to put their name to paper, certifying under the penalty of perjury. And along with that, now you have the worries about clawbacks of executive compensation and things of that nature taking a lot more emphasis. Let's move into the next slides then. We've been talking about the evolving issues of corporate compliance, and as Luke pointed out, the principles of federal prosecution of businesses, Holder Memo. Actually, I trace back kind of the genesis to what the Sentencing Commission did on its own initiative when it created the organizational guidelines in around 1991, if my memory serves me correctly. And what was going on in 1991, by the way? Well, we had the S&L crisis. We were deep into the savings and loan crisis. It seems like we've been bouncing, frankly, from crisis to crisis, and kind of a generational thing. If you go back into the 70s, what caused the Congress to enact the Foreign Corrupt Practices Act was the revelations post-Watergate that there were these large multinational companies that were bribing foreign officials to get business or retain business. And the whole idea was this is unseemly, and so perhaps that began the evolution of Congress wanting to have the whole idea of accountability in the federal criminal system and mandating the creation of the U.S. Sentencing Commission. Before we got on, I was telling Greg what an aberration I think that the guidelines have turned to be, but that's just my opinion. I actually prosecuted before the guidelines took effect, and it seemed to me that we had a little bit more fairness in those days, but that's just an editorialization. But to go back to my point, the commission created these carrot and stick initiatives, ostensibly so that the companies would do the right thing, focused heavily on corporate compliance. And as you look at the organizational guidelines, the 7 core factors of what is an effective compliance program, those are always going to have to be in a compliance program. What this has evolved into, however, is agencies are now saying, well, we're not happy with compliance being conducted through the general counsel's office. We think that the corporate compliance ought to be done through a individual who has direct reports to the board of directors. And the concern there is that the role of a compliance officer differs from the role of an attorney for the entity. An attorney for the entity, we can't trust as much because they try to filter information, looking at things like privileges and what lawyers do, as opposed to we want basically a person who's going to, look at the entity itself and compliance with the law, and it's a different approach. And so there are some new incentives to have direct reports. You get a little bit more credit if you have it. You get a little less credit if you don't. And companies have been trying to adhere to the guidance under the organizational guidelines in the main, but they've had to convince DOJ prosecutors, as we noted, who may not really have experience, and there could be hindsight bias about their compliance programs, that despite the evidence of wrongdoing, the company's compliance measures functioned correctly. In other words, it's not infallible. There are these rogue individuals who can be out there doing things that no reasonable system was going to catch. People cooking the books, people lying, cheating, and stealing. That happens all the day long. And if you're in a big enough entity with lots of subsidiaries, you can only do what you can do. But the emphasis seems to be on harder and harder metrics in place, lots of testing and things of that nature. That seems to be the trend line that I see. Luke, what about you?
Yeah, I think that's right. I mean, I've yet to see a compliance policy that can prevent someone, if they wanted to, from going out and buying a burner phone and having these communications, or as you said, keeping a separate set of records. Maybe there's things that can detect that type of activities, but if you're determined to do it, I'm not sure that a compliance policy is always going to be the catch-all for it, unfortunately. People get very creative with this stuff.
So now we move into the heart of the discussion about what is an effective compliance program in the new day of what is now a effective compliance program. The metrics are a little different because they now have in-house experts at DOJ on telling us, was this an effective compliance program or not? Is that a good thing? Arguably that you have some more objectivity about it, but I think the devil's in the detail and how it plays out. It's certainly almost a recognition by DOJ that there was a need. As I mentioned, is your compliance program well designed? There is a concern about hindsight bias there in my mind. Well, going back to the factors in the Justice Manual, they've now articulated their standards, and was there a risk-based and integrated processes approach to compliance? It needs to be kind of scalable, if you would. If I'm, for example, a multinational company doing business in high-risk areas, what kind of risk-based processes do I need? Well, there are third-party vendors out there that specialize in some of these things. Integrated processes, you've got to be in a position that the overarching compliance is set up so that the main entity is aware of what the subsidiaries are doing, what type of controls are appropriate. Again, that's a kind of a factual analysis there. How about relationships management? Compliance needs to look very carefully at vendors. They have to look at, who are your subcontractors? How are they instructed? Do you require them to give you certifications that they are abiding by all the rules that the company has for their employees? Real actions and consequences. In other words, if there is wrongdoing, does somebody look into it and is action taken? Is somebody who's under suspicion being adequately investigated? Are they still the fox guarding the hen house, or are they put on suspension, reassigned, something of that nature? And they have to be kind of balancing that if you're a company with the whole idea of opening yourself up to a civil lawsuit for retaliation. Is the compliance activity response being applied in good faith? How much has the company senior management, middle management bought in on the whole idea? Do do they talk the talk or do they walk the talk, as I've heard somebody euphemistically say? What incentives are in place to be compliant, and what disciplinary measures are in place to go after people that are non-compliant? Generally, my thinking about the whole approach of the guidelines and how government is acting is that, a carrot and stick approach is fine in concept, but it seems like we need a little bit more carrot and a lot less stick sometimes. Continuous improvement, periodic testing, and review are the buzzwords, but compliance is expensive, and all these things the government wants to have done is expensive. And so, at what point, from a scalability standpoint, is it realistic? Now we get into the areas where outside counsel or inside counsel have to deal with investigating misconduct. Is this an HR function, or should this be handled by the compliance officer, or should this be handled in tandem with outside counsel? It's kind of, again, a fact-based approach. Remediation of misconduct, what type of remediation is appropriate? Again, it's almost like pornography, when you see it, but you have to first discover the misconduct, and then you have to take appropriate action, with the idea being that what you may think is appropriate may not be considered appropriate by the DOJ. Going back to my hypothetical discussion, one of the things you do as outside counsel of a company that's under investigation is you try to engage in a dialogue with the government lawyers about what are you investigating. We don't have your search warrant affidavit; it's sealed. We can kind of read the tea leaves by what you've taken in the search warrant return, and what you're asking to get. But unless there's a little bit more transparency about what you think went wrong and why, we're not going to be in a great position to immediately remediate or do an analysis. We can do educated guesswork, but that's an imperfect approach. I'll turn it over to you for thoughts or comments.
Yeah, when this came down, I had a lot of clients asking about this. How many resources are enough? How much discipline is enough? If there's ever any doubt, I mean, you could have folks go in and do a review, but I think at the fundamental level, DOJ is looking at whether the individual employees have an opportunity to raise concerns and whether they're going to be heard. If it's top-down problems from leadership and there's an actual cultural problem at the company, none of these things are going to matter because you're going to have a problem. But I think that's at the fundamental level. That's what they want to see. If folks are empowered to do the right thing, if they see something, that there's measures in place to do that.
Let's move on to the next. Oh, we have a question, comment? Okay. This is always kind of a
Mike,
tough issue here.
I'll pose some questions. I'll be posing some questions that I've been getting from attendees at the end of the presentation. I'm compiling them as you speak.
Outstanding. I'm glad to hear that. It's always more fun to me to try to tailor our comments to what's jumping out at people, or frankly, not to be arrogant, I like to learn from people and their experience as well, Greg. So I appreciate that. Okay, so slide 11 is voluntary self-disclosure versus cooperation. And Luke, if you don't mind covering that. Sure.
Let's go back one. It's funny you mentioned Watergate, Michael, because I'm actually reading a book now by Garrett Graff, very well done, Watergate, A New History. And in it, in the beginning of the Watergate investigation, Archibald Cox, he received information about some conduit contribution schemes and companies doing foreign corruption, and a few of them came to his office directly with it, and he didn't charge them because he wanted to incentivize others to do the same. It was met with significant opprobrium at the time, but I think that was the first instance of a prosecutor doing that. And if you look at the Monaco memo, footnote 6 here, voluntary self-disclosure of misconduct is distinct from cooperation with the government's investigation, and prosecutors should thus consider these factors separately and of course citing to the different justice manual points for each of those. This is the big carrot, I think, in the bag that's available. DOJ has said voluntary self-disclosure is the clearest path for a company to avoid a guilty plea or indictment. And I think there's a tendency among some to conflate the two things. The way I like to think of it, voluntary self-disclosure is the government didn't know about this. They weren't investigating it. You're telling them about it. As opposed to cooperation where they're investigating something and you're sharing information and hoping to receive some credit for it. And there's different programs for the voluntary self-disclosure that have been embedded in the Justice Manual themselves. One is for Foreign Corrupt Practices Act. You'll see it's in Justice Manual Section 9-47120. Antitrust has what they call their leniency program, and there's a Justice Manual section for that, and others as well. And of course, the cooperation factors that are in 9-28700. And the National Security Division actually has one now for export controls and sanction violations as well. So there's a big incentive for folks to, if they learn something, come forward, disclose it, and you will hopefully avoid a plea or an indictment, and that'll be the basis for a non-prosecution agreement.
Well, the thing that I think is probably going to be what I would see as the next model would be to broaden the leniency provisions that the Foreign Corrupt Practices Act section has, or unit has come up with, and kind of similar to the antitrust leniency policy, that if you're the first in the door, you have a chance to not only not get prosecuted, but some of your key individuals who otherwise might be criminally prosecuted have a chance to get a walk. The beauty of that, in my mind, is that you incentivize companies that may be colluding to come in the door and give up their competitors. And from a competition standpoint, it's kind of a win-win. If I can avoid being prosecuted and see my competitors get dinged, it's a little bit Machiavellian, but it works. So there's kind of an alignment with the government. My enemy is your enemy. And, it makes a hell of a lot of sense to go into segments of industry that may be problematic and have that kind of incentivization. The FCPA policy has evolved very similarly now. And, I kind of see that this approach, if the government is really relying on corporate America to help them police, it makes more sense in a lot of measures. One thing we haven't talked about is another important factor to this whole milieu is the proliferation of whistleblowers and bounties for the whistleblowers. We've had traditionally the IRS tax bounty program. We had a SEC whistleblower program that really got nowhere for many years. After Dodd-Frank, Congress enacted a reinvigorization of that, looked to borrow and did borrow from the IRS whistleblower program and from the FCA itself with the Key Tam program. And now we see that the CFTC and the SEC program is starting to bear some strong dividends. The False Claims Act seems to be growing not exponentially, but it's increasingly important in the whole idea of having insiders come to the government and tell them what's going on in the company. They're incentivized to do so because they're going to make money potentially. And there's a memo in place internally within the DOJ that if I get one of these referrals civilly, I share it with my criminal counterpart. And so we have the whole idea of these parallel proceedings proliferating. So it was an aside, Luke and Greg, but I think it's kind of a necessary aside to talk about how these investigations involving large companies have multiple footings and multiple fronts that corporate counsel or outside counsel have to advise them about.
Yeah, it's tricky, especially for voluntary self-disclosure. There's the timing element you'll see in footnote 7, reasonably prompt time after becoming aware of the offense. So you have to make some decisions fairly early on if you're going to go down that road.
but again, one of the problems there is if you're not getting any feedback from the government, it's kind of difficult to make a voluntary self-disclosure blindly. Although I think you have to do it. I think you have to do what you can and ask for continuous feedback and try to show that you're an honest broker along the way. And at some point, hopefully, they will say, well, they're doing the right thing, and counsel is somebody that I can trust and work with.
Right.
So you've got some great slides you put together about corporate resolutions, and you've tied it to FCPA, and you want to walk through some of this. We're on slide 12 now, Luke.
Sure, yeah. This is 2019. We have 2019 to 2021, and this is just the fraud section. So 7 Foreign Corrupt Practices Act resolutions, and then the other one is the Market Integrity and Major Fraud section, which is the securities unit of the fraud section. So total global monetary amounts of 3.2 billion, 2.8 from FCPA, 384 million from the securities. And then you'll see the 1.9 in total U.S. criminal monetary amounts. So busy year for 19, and you'll see a dip in the pandemic, of course. But
yeah, so we're gonna move for comparative purposes to 2020. It dropped off because the DOJ, like all the rest of us, were working remotely, and it became more difficult, among other things, right?
That's correct, but the amounts are higher. If you'll see, this is 8.9 billion. So there's a couple big cases on this particular year, especially for the FCPA one, 7.84 billion, 3.3 big resolutions, but of course less. I think even less in 2021, only 8. And you see 3 and 6 here for FCPA, but one of them was a joint FCPA securities case, so that's why it's doesn't add up there. 3.3 billion, and then total monetary penalties for 2.9. But again, big resolutions for FCPA, 649 million, and 2.82 billion for securities.
Okay, so now, if you don't mind kind of walking through the use of the racketeering laws and white collar prosecutions and how that seems to be reemerging, if you would.
Sure. So this isn't entirely new. Giuliani used RICO in the 80s against some insider trading folks, but it's been reappearing as of late. And in the first case here, U.S. versus Greg Smith out of Chicago, this was a spoofing prosecution. The precious metals desk at a bank was engaging in spoofing activity, which is a crime under the Commodities Exchange Act. Essentially, if you have the intent to cancel a bid at the time it's placed or before execution, that's a felony because you're artificially moving commodities prices. You're just trying to influence the price and ride the waves on that. So sort of a tough start for DOJ on several spoofing prosecutions. One was dismissed in Connecticut for lack of venue. Another one, there was an acquittal. Another one, they dropped the charges. So I think in this particular case, they went in very heavy-handed with conspiracy with RICO, and this was a trial last summer. Shows how smart juries are. They acquitted on the RICO, convicted on everything else, and there was really no reason to do RICO because the penalties were as high under the wire fraud and under the other bank fraud statutes that they brought. But I guess they thought it was an easier way to package the narrative to the jury. And then the Southern District of New York, they recently did the same with Archegos trading U.S. versus Hawaii. This is pending trial, so these are just allegations, of course. But there's an allegation that with swaps that they artificially increased the price of their portfolio and went from a $1.5 billion portfolio to $35 billion. Doing these types of activities. Again, RICO charges brought in that case. We'll see how that plays out at trial. And of course, the one that's not on here, but that Michael and I have talked about is the founder of incest in the District of Massachusetts, Mr. Kapoor. That was a RICO prosecution as well. He was convicted. It was affirmed by the First Circuit. But it's interesting to use this statute that's traditionally been for organized crime offenses in the context of white-collar prosecutions, which already have significant statutory maximum penalties. We've written a piece on this that is in the materials about whether this is advisable or not. My view is it should be used sparingly, only when necessary, but I guess others can have differing views. What do you think, Michael, about the resurgence of RICO and white-collar prosecutions?
I agree with you. When I was the criminal chief, I had AUSAs that wanted to use RICO, and I would say, look, we have forfeiture laws, we've got money laundering statutes. This is overkill. Now, with RICO, you do get the opportunity to extend the statute of limitations, but you've got to demonstrate, that there is a pattern of racketeering activity. That's 2 or more discrete violations. And you also have to get specific approval at Maine Justice for the use of RICO. You do get a little bit of an evidentiary advantage. It's kind of taking the conspiracy laws one step further. But I just recognize that federal district courts do not like RICO generally, particularly in civil litigation where it has been overused. And I think the problem with the government lawyers, and particularly young, aggressive prosecutors, is that if you have these powerful tools and you use them all the time, the courts will at some point start curtailing your ability to use those statutes. They start drawing lines when they get the appropriate case that shows that it was excessive and inappropriately used. So I fully agree with you.
And it's been used also in public corruption cases, but usually it's when there's a diffuse set of alleged offense conduct that a lot of it's maybe state offenses. It wouldn't be normal to join the rules under regular circumstances, but you can cobble it together that way, and it makes sense there. I'm not sure I understand the reasoning so much in these cases that we highlight here.
No, I'm generally not a big fan of it. I remember at one point that I taught at the Attorney General's Advisory Institute a class on RICO, and I'm telling you what I told the people back then. I had, back in the day when I ran the bank fraud division, I had a couple of USAs in particular that wanted to RICOize everything, and I just refused to approve it. And so I just think you have to do quality control. And that's always been my thinking. And, philosophically, even when I was a prosecutor, you have to be mindful of the fact that proportionality is important, and the courts will grade your paper. And that's really it. And I think that RICO made sense in the mob activities. It may make sense in specific cases, but they should be few and far between.
Agreed. Yeah.
Okay, so we're nearing the end. What are some of the potential outcomes that you can get? Well, no adverse findings or disclosure obligations. That's where the client loves you and wants to come back to you. All of y'all that practice in the white collar area, the ideal situation, if you do a really great job, your client is not publicly dragged through the mud, and there's not reputational ruin and the financial burden. I try to explain this to our marketing people. I can't really count on clients that I've kept from being recognized as somebody that might have been indicted, wanting to talk about that to their friends or others. So that's one of the problems in white collar marketing, is that unlike a civil engagement, rare do you get multiple opportunities to have the same client again. What other outcomes? Compliance program reforms. We all know that we've kind of gone into that it's getting harder and harder to meet the standards. They're evolving. The sin is to have a program and not use it. The sin is to have a program on the shelf, and it's not implemented. The government will argue, well, they were well aware of their compliance obligations. Here's their plan, ladies and gentlemen. They didn't follow it. It was window dressing. Self-reporting, we've talked about that. Administrative action on discrete issues. We haven't really talked about that too much, but in the scheme of things, you got to look at it again holistically. If you can avoid the criminal world, pick your poison. Administrative actions sometimes are really not negotiable. It's a home field advantage problem, and you just pick your battle. Consent decrees, not a good thing. We haven't gone into great detail about the SEC and how to negotiate with the SEC, but oftentimes, you're going to have to work out a resolution, and they're going to want to have a consent decree. Civil lawsuits, very dangerous area where you have parallel proceedings. I've got one right now, a client where we're aware of a sealed key tam because it got filed, but it wasn't closed down in time. So the clerk's office, district clerk, shows that a key tam was filed. We know who filed it. We know who it was filed against. And my poor client has a active DOJ investigation out of Main Justice civilly, a criminal investigation out of one of the branches, and a civil lawsuit. Other actions, installation of monitors to oversee operations. We chatted about that. Criminal charges, we've kind of talked about that directly. Declination, success, right? Isn't that how we measure success, declination? Deferred or non-prosecution agreements for the company, again, great. One thing we haven't talked about, which I found to be part of the problem back in the days of Holder and Thompson, that it's kind of continued, is there's this culture of finding somebody to scapegoat and throw as raw meat to the government on behalf of the company, claiming that they were a rogue employee or the rogue person, and the sacrificial lamb that could be presented for slaughter to avoid the company being charged. In the beginning of the corporate emphasis, the goal, it seemed to be, was that the company needed to survive to buy peace, but would be willing to take a ding to protect the high executives. Then it has kind of migrated, it did migrate into find a sacrificial lamb for the company to survive. And if you're talking about a publicly traded company, that may make some sense. But now, this is a problem. And I think, Greg, when we were preparing for this presentation, we talked about it. At what point, if I'm a company counsel, outside counsel doing an internal investigation, do I cross, at least in my judgment, what I feel is to be kind of an ethical issue about in interrogating somebody, giving them the reverse Miranda warnings? I'm not your lawyer. The company has the privilege. The company may desire to waive the privilege, but I want you to tell me everything that you did. As part of your employment agreement, you've agreed to cooperate, and tell us everything you did. And then, if I know going in the person did something wrong, is it better for me to tell the company that I will not be comfortable with, slicing and dicing them and turning them over? Some lawyers have no problem doing that. I'm not real comfortable with going in and doing that, quite frankly. I would rather say, I'd like to have somebody appointed, if there is a D&O insurance available or whatever, and try to work with the lawyer. I just, again, everybody has their own opinion about it, but I'm not comforted with doing that. Luke, I don't know if you have any thoughts about that.
Yeah, I agree. And to the point about if the strategy is to serve someone up, I'm not saying that that's right or not, but I think you better have a good sense of the lay of the land on the facts, because that could very easily boomerang back. They become cooperators, and it does a lot more harm than good. So I think you have to think long and hard about those types of decisions before they're made.
Yeah, I mean, that's one thing we haven't really talked about. If you go back to the whole idea of corporate criminal liability, um, which is one of the things that I think was lost perhaps on the idea of slicing and dicing somebody. If they can establish, the government can establish that a corporate officer who had decision-making authority or somebody affiliated that had decision-making authority did something that arguably was in the company's interest, then that's enough to establish corporate criminal liability, vicarious liability. And so the whole idea of slicing and dicing somebody up doesn't necessarily mean that the company's going to get a pass. Years ago, I represented the head of energy trading for Reliant Energy. Now, my guy, fortunately, had retired before all hell broke loose, so I was in a little bit of a better posture. But at that time, the company tried to do the right thing and had great lawyers representing it. And, so the press was initially that we had rogue employees who were out there doing stupid things, and that's not part of what we do. Subsequently, the company got indicted with these people. And so it was not easy for us to join hands and fight the government after, there was a lot of distrust about let's work together after you threw us under the bus. That was unacceptable, right? And we had a good outcome, but it took a lot of effort by the lawyers to try to keep that team together. We did, and ultimately the government gave us a non-prosecution agreement on the verge of a 6-month trial. We had gone out, had a hotel rooms ready for a 6-month trial, and on the Friday before Monday jury impanelment, they said, would you all be willing to take a non-prosecution agreement? And it was not a hard decision. So,
worst places to be stuck for 6 months, though, than San Francisco.
No, San Francisco is beautiful.
Beautiful town.
A beautiful town. Now, the federal courthouse is in the Tenderloin district of San Francisco, which is not a beautiful place, but apart from that. So, Greg, I think we're at the point now, if you don't mind, of
Sure.
listening to some questions and
You
visiting a little bit.
And actually, they're all over the place, so there's no rhyme or reason. But if it's okay, I'm going to take the ball back, Mike, so I can segue to specific slides, because actually the questions are now slide specific. So let me, yeah, it's actually very interesting. The concept of the joint defense agreement. This is more than one comment and question. Let me see if I can just sort of merge them into a single question for both of you. JDA's company is under investigation, has a major law firm like yours representing the company. Employees are targets consistent with the individual accountability, at least subjects, if not outright targets. The company wants to pay for the attorneys for the individual employees and is requesting a joint defense agreement so that everybody's on the team. And both of you have used the word team during the presentation. So there's a kind of team consciousness in this undertaking. But now the issue is really whether or not the company, how does the company, outside counsel, factor individual accountability, the renewed emphasis on the Sally Yates philosophy or policy, into its presentation to the U.S. Attorney's Office? Because now you got a JDA and you're working with the attorneys for the individual employees. The company really wants to give a presentation that splits the company off from the employee. Mike, you go back years to the concept of the rogue employee was a concept that it would almost became a mantra back in the Reagan years, specifically with procurement fraud defense issues and subcontractors running their own little sideshows, and the general contractor, Northrop, Lockheed, they're on the hook. But now you got a JDA with the individual employees, and there are issues about the extent to which outside corporate counsel for the company can implicate them in its presentation to the government. Give us some thoughts on that.
I'm not sure if, I'm sorry, go ahead, Michael.
No, I'm happy to let you go first.
I was just going to say, I'm not sure if I would do a JDA under those circumstances. I'm not sure there's a common interest there if the employees have been identified as targets, but the company has not, and the company's in a cooperative stance. So sort of disagree with maybe the premise of the question, but Mike, go ahead. Your thoughts.
Actually, Luke,
Well,
I think that's a really important
think-
piece of feedback. Mike, I'm inclined to agree with that. A JDA is itself a strategic error on the company's part, don't you think?
Right. I would think that maybe if you have that situation, you may have entered into a JDA, and now it has come to pass that the company learns that the government thinks that these individuals are targets, and the company wants to avoid going down with them. I think at that point, you look at the JDA, it should have a provision saying that you need to stop participating in the JDA once you have started having audiences with the government about resolutions. And so at that point, I would advise the company not to stay in the JDA if you want to go to the government and start trying to cooperate. I think that you do your withdrawal and you tell the other people that we're no longer going to participate. That's the way I would handle
That was
it.
another.
And usually there's a clause that you can't share any of the communications that were subject to the joint defense, right?
And that would really be why the JDA is counterproductive to the company if the company is already aware of misconduct by the employee and wants to split off. And those privileged discussions within the JDA are not disclosable to the government. But the other question I have here regarding JDAs is, and I think you've answered it, but to what extent should the JDA maintain internal flexibility? Because if the company has a JDA, but in the course of its internal investigation identifies one or more employees who are part of that as actually perpetrating the corporate misconduct, talk about the way in which the company can exit from the JDA and by doing so retain its flexibility to split itself off from that employee without violating the agreement. It's a tricky subject.
It's really tricky. I mean, I would be reticent in entering it in the first instance. Not a broad JDA. Maybe arguably you could do a limited JDA on document sharing, document repositories, things where you can control costs by having like a relativity database everybody can go to. But as far as communications and strategies and things of that nature, if I'm representing a company, I'm going to probably, unless it's just clear that there really isn't any potential liability, I'd be very reticent about going into a CIA, a CIPA, I guess, a Common Interest Protection Agreement, or a JDA, because the downside risks are too great.
Very good feedback. Luke, anything further on JDAs? And then we'll move to the next question.
I would just say, my recommendation for that is read them very, very carefully, because I've seen a lot of different clauses weighted very much in favor of the government when I'm representing the company when I'm representing individuals, and vice versa. So I think you want to think long and hard about it and explain it to your client if this is what he or she actually wants to do when you're representing individuals, because it's a divergence point.
I want to stay with you. Yeah, Luke, let me stay with your point outside the corporate criminal context. It's such an important point that you're making, because the government could very well treat your individual client as damaged goods. The government doesn't want to risk that a proffer session, let's say in the course of the litigation, you realize cooperation is probably your best exit strategy, and you want to do an immunized proffer session. The government says, if you're part of a JDA, we're not in a position to determine whether JDA related information is going to be disclosed during the proffer, so we really would rather not. And so the opportunity to cooperate can be, at least in theory, foreclosed just by being part of a JDA. Is that part of the point you were emphasizing?
Yeah, it is. And it don't necessarily have to be in writing, don't forget, in order to you can have a JDA that's not actually written, which is another option.
Okay. Next issue is receivers. The installation of a monitor as one of the potential outcomes listed here in slide 16. The question is, in what way, if at all, the monitor, who has to at some future point certify or validate the efficacy of the compliance program, is going to be allowed to have some measure of control or perhaps oversight over day-to-day management decisions or access to books and records that would otherwise be regarded as confidential, which puts that monitor almost in the position of being a court-appointed receiver, not quite, but it's getting perilously close. That's the question for both of you. Do you see an analogy there between the monitor and the receiver?
Short answer is yes. I think that's one of the downsides of it. And, you know, if you get a corporate monitor who is unreasonable, it can be very, very dangerous to a company, very, very expensive, and interfere with their operations to the point where it can really harm the company.
And it's very expensive, and I think if they're not getting access, I mean, they're just going back to the prosecutor, and that just reopens the whole thing too. But yeah, I agree. It's an elephant on the company's back, to be sure.
Question on footnote 7 of the Monica memo. You were discussing this, Luke. This is slide number 11 in regard to voluntary disclosure and how you drew a very good distinction between self-disclosure on the one hand, which is proactive before the government comes knocking on your door, and cooperation, which is after the fact. And the question here is whether or not the voluntary disclosure policy today echoes historical practices where the government required the waiver of attorney-client and work product privilege in order to get the full benefit of self-disclosure.
That's a great question. They say it does not require it, but in practice, as everyone knows, I think it actually does if you're doing the facts and giving the information that they want to know. But what's different, I think, about the Monaco and these voluntary self-disclosures is they want it done earlier than it's done before, which places more burden on the defense counsels to get that investigation wrapped up, to learn what's going on quicker. So that's sort of the challenge with this, is everything's got to be done sooner, it feels like, which is challenging.
Mike, picking up on Luke's point about, having to wrap up that internal investigation, if you're going to be proactive and do a self-disclosure, you're going to be working from the internal investigation, which by definition contains a substantial amount of privileged information. How can you not do a voluntary self-disclosure and still retain the privilege? You're going to have to waive it. What are your thoughts?
You can waive the DOJ outlines, the fact work product versus the core work product or the impression work product. But as a practical matter, you're right. I think that there's a big waiver problem there, and can you avoid it? Probably not.
Right.
And implicitly, although they can't ask for it, they want it. They want it.
Yeah, I mean that's been even policy in the past that they precondition
That's right.
the credit on the waiver. That's been my experience. Does that track your dialogues as well? They precondition the waiver. Yeah. Another question is informal production to the government as corporate counsel to avoid a grand jury subpoena. And that would imply, and you mentioned this today, staggering production. That's almost a given that you don't do everything at once. But to the extent, discuss how you might be proactive in preventing a formal subpoena by reaching out and having discussions about subject areas that involve documents to be produced informally. Mike?
Well, it's not risk-free there either by making informal productions. You better have an idea of where this may be heading. What you don't want to do is to open up the Pandora's box. And so, if there's things that you think are important, that are useful, that don't have a boomerang effect, that's where you'll do it. And again, that's part of saying, we're open, we're going full kimono open, we're trying to avoid, ugly things, and there's no need to do subpoenas at this point. We'll work with you. That's about all you can do.
Oh, but it's good feedback. Another question here, dealing with DOJ's tendency to investigate companies now in new economies, cryptocurrency, for example, or in the healthcare field, Mike, this is clearly your expertise, companies that manufacture high-tech medical devices, non-invasive surgical procedures, etc. which involve a high level of sophistication in science that is far beyond the prosecutors and the FBI. I'll just throw in my own comment that I'm dealing with a cryptocurrency case. The FBI is not well trained in that area, but they're only too quick to pass judgment. And so the question is, do you now find yourselves bringing expert witnesses into the dialogue process with the government? An expert, this is me talking now, an expert, for example, dealing with a particular medical device who can really educate the government on, you know, the level of efficacy of this particular instrument. Thus, there is no misrepresentation of hospitals and physicians in the way the product is being marketed. Expert witnesses in the dialogue with the government. Luke, let me turn to you first, just to go back and forth, and then Mike, please.
So the first part on the sophistication of different areas of investigation, specifically the cryptos, I think that was one of the reasons they stood up the cryptocurrency task force, which is headed up by Young Choi, who was a former AUSA from the Southern District of New York. So the expertise is getting a bit better with respect to that, and agents are getting greater specialties in these very sophisticated areas. But for experts, I think that's very important and an important point, even if it comes down to negotiations in a healthcare fraud prosecution, to have somebody explaining to the government and the agent, by the way, your dose calculations are incorrect under the CMS guidelines or whatever it is. I think that's always an important option to draw upon for those very hyper technical cases. You see it a lot with semiconductor investigations with sanctions too. What parts are being made? What are these parts specifically, and where do they fall in the category of non-export controls or things like that? Yeah,
has it
very important point.
Has it been your experience, Luke, that the government tends to prejudge, and you've had to use experts to really?
Of course, yeah. They have their understanding that they're wedded to, and
sure.
But you can persuade them, right? Sometimes.
Mike, use of experts.
Oh, I've had some experience in that regard. Yeah, I think that, you have to find a way to educate them that they're wrong without insulting them. And so having experts that can come in and explain where they've gone wrong. I had a doctor one time that had not one, but two target letters, one from a U.S. Attorney's Office and one from DOJ. And it all came down to they misunderstood some of the applicable billing and coding regulations. And I picked that up early, and I said, look, I'm going to come in and give you a briefing. I'm going to bring an expert in and explain to you why this theory doesn't work. And that basically was successful. Now, I've also had clients where we brought in in-house experts to explain processes that they didn't understand, where they thought there was some wrongdoing, and was able to show them that no, it really was not wrongdoing. And again, it's trying to know your audience and try to work with them to understand that what the agents are bringing to the table may not be accurate. So I think that's a good technique.
Got it.
Obviously, there's a risk component to it if you do that, and you get somebody on the other side who is not necessarily receptive. All you've done is you play your hand out, but I think it's worth the risk.
Luke, any follow-up before we move on?
No, I think we move on.
Great. Next is a comment mixed with a question. This attendee has found it frustrating that the government tends to look at non-compliance in black and white terms. Your slide 10, Mike, you talked about the risk-based component of the compliance program, and the comment here is that non-compliance can often be in the eyes of the beholder. It can be subjective because compliance risk assessments really look to how the company might not meet its regulatory compliance obligations, and reasonable people can differ in that regard. And the question is, can you talk about the subjective nature of noncompliance when the government has a tendency to see things in such black and white terms, and how you work with that?
Well, I'll tell you, for an example, I'm sorry, Luke, I've got a matter right now. It's not a criminal case. It's a False Claims Act investigation where I've had back and forth dialogue with the AUSA, who is trying to essentially say in a kickback safe harbor, your client only met 7 of the 8 factors. to fall within the small investment safe harbor, which has a 40% threshold. And my point is, well, this is not a stark case where it is a you're in or you're out analysis. It's essentially an intent-based regime. And if you look at the Office of the Inspector General's review of voluntary disclosures and advisory opinions and their literature, it's a holistic approach. So it's not a check the box approach. And to that extent, you know, the subjective and the objective meld together, but you fail to consider the fact that they've done everything they can to get as close to the safe harbor as they can, and there's other things that you need to consider, so your approach is wrong. Now, how do you say that in a way that's not insulting? You know, you have to give them the literature and point it out. That's yet to be determined. It may be one that we end up having to try, but I do think that beauty is in the eye of the beholder, and a lot of these prosecutors do tend to see these things as black and white when they are nuanced issues.
Luke, I mean, there are black and white non-compliances like just flat out kickbacks under Title 42, but there is a subjective element to risk assessment as well, as you know. What are your thoughts on communicating the subjective nature of non-compliance, as Mike suggested, that we have to quietly explain to them that their assessment, their view of it is incorrect? How do you go about it?
Yeah, it's an important point, because if you're an international public conglomerate that does business in areas that are known for corruption, let's say around the world, and you don't have a risk-based system for Foreign Corrupt Practices Act or the use of third parties for donations and whatnot, sure, that's obvious, that's black and white. But what concerns me about the in-house compliance aspect of it is having these folks substituting their judgment for companies is, it's not a one-size-fits-all. You could be a medium-sized private company. You're not going to have a compliance department that looks like Hewlett-Packard's, HP's. And I don't think it's reasonable to expect to have that, right? These are small margins. These folks have to be payroll. So that's my sort of concern with having these perspectives now embedded at DOJ, is what the view is going to be of what a proper compliance department should look like, without taking into account these various factors, size, and where they do business, and these other risk-based things.
You know, an example that comes to mind as I listen to you in the different sizes of companies is record-keeping practices. Mike, you do a lot of healthcare. The home health agencies, the hospices, their record-keeping practices may be in compliance with CMS, but may not be what the auditors are requiring, because they're not at the same scale as hospitals. Have you found that record-keeping is sometimes an issue in these debates over non-compliance in healthcare?
I mean, it typically comes up in the context of overpayment demands, and you know, was the record keeping up to the standards that are required by the Medicare contractors and CMS guidances and things of that nature. It can percolate into you know, other arenas, and you know, there seems to be kind of a melding of attitudes about what in the old days used to be called abuse, and now they're looking at it as fraud, and they're looking at, you know, sloppy record keeping as fraud, when it's just sloppy record keeping. And so you know, if you go classically, what is abuse versus what is fraud, there's an intent element to it. Unless you can show that these records were intentionally kept in a haphazard fashion to kind of game the system, it shouldn't be looked at as fraud. It should be looked at as abusive.
That's an important distinction. One more question is in the context of the calculation of corporate financial gain from what the government claims as misconduct. We know the organizational guidelines will address that. It also goes to fines. The question is, how do you work with perhaps an outside accountant or your own in-house accounting department in coming up with some measurement financially? Give a dollar figure that you can discuss with the government. It's just the process of working with the financial folks to propose a figure that makes some sense.
Oh, look, if you want to talk about that, I've been talking too much. Go ahead.
Well, sure. I think it's significant to work with them early on. I think we want to loop those folks in. We've done that in a number of different types of cases, whether they're financial fraud related or in the healthcare context. But I think you want to loop those folks in so they have a good understanding of the facts, because that will drive the guideline calculation and the fine amount, as you said, significantly. So early and often, you want to partner with those people and make sure that everything's covered by the privilege and they're part of the team.
You know, that's so important, bringing the accountants in right at the outset. Just before we move on, inside accounting department, or do you tend to outsource it to a forensic accounting firm?
You want it to have its own credibility and for the calculation to be able to stand on its own 2 feet. So I'd say outside, typically.
Mm-hmm. Mike, your thoughts?
I agree. We just settled a False Claims Act investigation in one of the districts, and we brought in a high-level outside accountant that accounting firm. And you know what you want to be able to do is to show the government that your calculations and your methodology are better than theirs, and the metrics are better than theirs, and you could get a lot more control that way. And so, yeah, it's money well spent.
And the last topic is the use. Oh, Luke, did you have any final thoughts before we move on?
I was just going to say, Greg, for that particular one, if there's an inability to pay issue, you have to think about how the optics of that looks, though, for the government. Because if you're claiming there's an inability to pay, maybe you do it in-house, as opposed to paying a big fee to an outside vendor.
Got it. Last topic, because we're beyond our allotted time, is the use of RICO in white collar, as you've already discussed, which is slide number 15. And Luke, you were discussing this, and I'm going to start with you because you worked at DOJ. You did public corruption at a high-profile scale. My thought, and this is me talking, is that RICO is really more of a leverage than a substantively useful violation. You know, the government can achieve what it needs to, and you gave the example of the trial where the RICO count resulted in an acquittal, but the sentencing outcome really was indistinguishable because the sentences were the same, if not greater, on the wire fraud where the client got convicted. But my thought is RICO is used as a leverage to induce a plea, particularly where the rest of the counts may be debatable, because there are stock value implications here. You know, you're challenging the entity as a whole, the organized crime family as a whole. We've seen a lot of street gangs indicted for RICO there. It's all about the systemic nature of criminality within the organization. And that is the perception that's being conveyed in a RICO count, which can have real ripple effects in regard to stock value. So the company will be quick to settle, even if the case was defensible on other counts. Luke, your thoughts? You know the mindset at DOJ.
Yeah, I agree. I think that's absolutely right. You know, it's a heavy lever to pull. It opens you up to consecutive sentences for the RICO and the predicate offenses. There's a lot of other tools that make it attractive, and it'll extend limitations periods significantly. And for the rules on joinder, severance, and unfair prejudice, it's a little bit different with RICO. They can hear multiple things. The venue is a little bit different. To be sure, it's but for something like a financial fraud case, wire fraud and mail fraud, you know, you're in the 20 to 30 range, and if it affects a financial institution, RICO statutory max is 20 years. There's really no substantive reason to use it other than what you described, those tactical reasons, in my view, for the specific offenses.
You know, you can.
Now, sure, there's exceptions to that for the public corruption case that I mentioned, where you wouldn't be able to join them all, and it lets you talk about a lot of state offenses that you bring into federal court, but those are few and far between, right?
You can charge more individuals because they don't have to be members of a criminal agreement in the literal sense, like a conspiracy. They can just have, by virtue of their affiliation with the entity. So you have a wider net as far as individual defendants. That would just be a thought to offer. Mike, your thoughts on use of RICO as leverage to induce early pleas?
I think you all have covered it ably, Greg and Luke. It is a tool that can bring everybody to the table. It's kind of hard for the entity to want to go to trial with a RICO case out there for the obvious reasons. If it's not a publicly traded company and they don't rely on lenders, maybe, but other than that, I can't imagine. Yeah.
We're past our time. Let me just ask you both to give just a brief closing remarks. Anything that you'd like to say to wrap it up, and then we're going to thank our audience for being here today. Mike, just a couple of final thoughts.
Well, we thank Greg. It's been a real privilege and honor to do this. Thanks for inviting us. I think this is an evolving area. The guidances that we're getting are obviously, with this administration, targeting entities. The dialogue out there politically is that companies aren't paying sufficient taxes. There's a tendency to blame corporate America for excessive profit taking, and now that we have a lot more issues going on, I think we're seeing a resurgence of targeting companies. So this is a target-rich environment.
Luke?
Yeah, I agree, absolutely. They said there's a 10% increase. I think a lot of that was PPP fund. I think after the new year, as Michael said, you're going to see significant actions coming down from the department, and we'll see how these policies play out in real life and how enforcement trends continue to inform their evolution.
Well,
thank you very much for taking the time to speak with us, and for all those that attended. Appreciate it.
Absolutely. I certainly thank the attendees, and with target-rich environment, Mike, and we're going to see things down the pike. Luke, I'm going to ask both of you maybe in a half a year or so to reconvene and see what's come out of DOJ based on everything you've discussed today. I want to thank again Luke Cass and Michael Clark very much for being here. I look forward to having you back, and thank you all. The app, which is what you've been attending through, will automatically generate an email to you a certificate of attendance. This program has been pre-approved for 1.5 hours in California, MCLE. So thank you again. Have a wonderful rest of the weekend, and we'll see you soon.